The Honorables, the presiding judge and judges of the Court of Appeals of the state of North Carolina. Oh yes, oh yes, oh yes, the Court of Appeals is now in session. God save the state and this honorable court.
Good morning, everyone, and thank you for being here for this remote session of the North Carolina Court of Appeals. I'm Richard Dietz, and I'm joined today on the bench, but remotely by my colleagues, Judge Phil Berger and Judge John Airwood. We have one case on the calendar today, and that's number 19897, State v. Turner. And with that, we'll hear from counsel for the appellant.
I am Jim Glover. I represent John Turner. He is here before this court appealing from his conviction for the first-degree murder of Nick Parker. There was no dispute in this case that John Turner shot Parker and that shooting was the cause of death. The only issue in the case was whether or not it was self-defense. The case in this court raises but a single issue. Some 3 years after the event, the state sent the firearm that was used in the shooting and asked him to test fire the gun to conduct an experiment about the pattern of shell casings that were ejected by the gun. When the state offered that evidence and asked the court to find Mr. Glass a expert on this issue, there was a defense objection, there was a voir dire, and then the trial judge ruled that Mr. Glass could testify as an expert about and he gave that testimony to the jury. The question before the court, the question raised in our appeal, is whether this experiment was conducted under circumstances that were substantially similar to the circumstances at the time of the shooting. Exact similarity is not required.
Can I ask a preliminary question about the standard of review on that question? So in your brief, you assert that although the admission of expert testimony is reviewed for abuse of discretion, the issue you're raising, this issue of substantial similarity, is a legal question that the court reviews de novo. You've cited some cases to support that predate the recent changes to the rule of evidence that governs here, 702 North Carolina Rules of Evidence. Your friend for the state asserts that that's not the standard, that under cases from the Supreme Court applying the rules of evidence, the standard is just abuse of discretion. I think that's an important issue for us to understand how we're viewing this case. So could you address that question?
Try to. The case we cited, State versus Jones, decided by the North Carolina Supreme Court, talks about that at some length, about the court's discretion, and basically what they said is admissibility is within the discretion of the court, but the issue of whether there are enough similarities between the experiment and the event at the time of the crime. They said, I think the cases that have been more recent than that have changed that law. The discussion, Jones, is quite lengthy. And they talk about it starting out as an abuse of discretion standard, but they also talk about it on this question of whether there is substantial similarity, that being If it's too far from the mark, it's a question of law. That's what they said. The cases since that time don't mention discretion as Jones did, but do not, as I read them, overrule what the court said in Jones. Did that answer your question, Judge Deeds? Did you hear me?
It does, thank you. So let me then ask a follow-up question, which is the substantial similarity doctrine that you reference predates not only sort of the modern rules of evidence that we now view as being coextensive with what we call Daubert principles, but also predates the rules of evidence themselves. So I think your friend for the state is going to argue that that's not even really the standard here. The standard is the test that's laid out in McGrady and other cases, which is, I think, with respect to this substantial similarity question, one of the reliability of the data, the methodology used by the expert, and then the application of that methodology to the data. And that substantial similarity might be a concept that you apply there, but it's not the test anymore. So what's your response to that?
Well, what I suggest is it is still a test. As when the rules of evidence were first enacted with respect to this issue, the commentary says they do not change the prior practice. This issue of evidence is a small category of issues relating to testimony that is put on by a witness. Sometimes the witness is an expert. Sometimes the experiment is done by somebody that's not an expert. But the issue of whether you can do this kind of experiment and then put it before the jury has to do with the experiment, not the traditional kind of expert witness issue under the rules of evidence. It's a special category of a problem, and the category didn't change since. I think we've cited one case where this court overruled a trial court. It was a civil case, and that was after, I think, the rules of evidence were done. I'm sorry, I got the wrong word. Okay.
Yes, I think you cited Addison versus Moss.
Yes.
And the interesting thing about that case, which I believe is the mid-1990s, is that case references back to the pre-rules of evidence cases, and it predates what we might refer to as the modern standard, the one that came in 2011 and after when our state clarified that we were going to have this standard that mirrors federal law and follows federal doctrine on these questions of the admission of expert testimony. So I think what we're going to hear from your friend for the state is that the argument that needs to be made is one that fits into the kind of modern McGrady Godwin style analysis that's been done in those Supreme Court cases in the last few years, and that substantial similarity is not a test anymore. It's just one factor to consider in weighing whether the trial court's decision was an abuse of discretion. In other words, given all the different factors. So I think what I'm asking you is persuade us that we should consider that one factor so determinative that if we disagree with the trial court on that, under a de novo review, we can reject the admission of that testimony as impermissible.
You not only can, but you must. The whole issue about experiments and putting before the jury the results of an experiment has to do with whether this is going to enlighten the jury, be useful to them, or whether it's going to be the kind of thing that could mislead them. And the rule about substantial similarity in the circumstances goes to that issue. Now, there is a way to put that under a number of the Daubert standards under the new statute, but I don't think it changes the issue. I don't think it changes the law. I don't think it changes the requirement that if there is not substantial similarity in the circumstances, then the experiment can only mislead and confuse the jury.
Mr.
Mr.
Glover,
Jerome.
why wouldn't this fall within the purview of 702A2, where it talks about that the testimony is a product of reliable principles and methods? Why doesn't that cover this and therefore put this back under the grave?
Well, I think it can fit under that definition. And in fact, that's the argument we made in our reply brief. If the experiment is not substantially similar, then facts were not, then the method is one in which, I'm sorry, let me get it. Then the witness has not applied the method in a manner which applies reliably to the facts of the case. It's the same question. It just is the same question. You can give it a different label, but it's the same question.
But if it falls under the rule, then why aren't we in an abuse of discretion standard as opposed to the de novo standard that you're proposing?
Because the cases dealing with experiments deal with when experiments are useful, when experiments are not useful. They're not useful when they have the potential to mislead the jury. And when the circumstances are not substantially similar, they do mislead the jury, and that's exactly what happened in this case. I don't think it makes any difference whether you apply it under the rubric of 702 as it's been most recently amended. The question is, if we go under that rule, we still have the requirement can be put before the jury. If it's not substantially similar, then it is not reliable. And the old cases tell us how to look at that question about substantial similarities. They don't have to be exactly similar. They have to be substantially similar. Did that answer your question, Judge Arrowood?
I understand your position, yes, sir.
Okay. The circumstances at the time of the shooting were entirely different from those at the time of the experiment by Mr. Glover. The defendant testified that after Nick Parker said he was going to shoot him, like he had just shot the dog, and he's going to get it over with, and started down toward him, got down to the road level, to the ground. That's nothing like what happened with the experiment. The experiment was done with a trained officer with a firm grip on the gun, holding it perpendicular to the ground, and then firing 5 shots, first parallel to the ground, 45 degrees down, 60 degrees down. These differences are outlined, but not addressed by the state at all. Although the witness, Mr. Glass, acknowledged that each of these things would affect how the shell casing would be ejected, even though he had never done any of this and never took any courses on it and didn't even know the literature on it. But there were different kinds of ammunition used. Mr. Glass agreed that would affect how the shell casings would come out of the gun and the pattern that they form when they come out. The surface was different. The shell casings in the experiment were fired standing on grass. The shell casing came out, landed on the grass, did not move. At the time of the shooting, the shell casings were fired, some of them landing on hard gravel, where obviously they bounced, and may have been bumped after they hit the ground because the defendant had to go over and approach the victim at the request of the 411 operator. In the experiment, the gun was held steady in a firm grip. At the time of the shooting, the gun was in motion. The defendant was in motion, the gun was in motion. We don't know whether the gun was canted or not, but obviously if he was moving and falling down, it would tend to cant the weapon. The weapon in the experiment was not. The other issue that was clearly a matter that would affect how the casings came out and formed a pattern was how the gun was held. There was testimony from another expert who examined the shell casings, determined they all were fired by that gun. And she talked about what's called a limp wrist. Limp wristing. In the experiment, it was held in a firm grip. At the time of the shooting, some of it was not held that way. And again, Mr. Glass admitted that would affect the pattern. Because of all of these differences, the fact that in the experiment, when the gun was held parallel to the ground, the shell casings went to the right and backward, did not replicate the circumstances, but the prosecutor took that experiment and said, if you look at the shell casings and the pattern on the ground, you can see that's not what happened. He was not backing up, he was moving forward. So the experiment was used to undercut the defendant's testimony. And the experiment was one which did not replicate what the defendant said was going on. It should not have been admitted. I don't have any more than that. Unless the court has some questions, I'll just save the rest of it for rebuttal.
All right, thank you, counsel. We'll hear from the state.
Thank you. Am I audible to everybody? Yes. Okay. May it please the court, I'm Tom Lawton. I'm a Special Deputy Attorney General. I have the privilege of addressing you from Asheville. And sometimes I like to say it's all quiet on the Western Front, but when there are earthquakes and pandemics, I don't know that I can. There are two parts to the state's argument. The first is that it is an abuse of discretion standard and that it was not an abuse of discretion to admit this testimony. Testimony from a certified forensic firearms examiner to testify about the distance and direction ejected shell patterns travel, which is within the purview of what forensic firearms examiners do. The second argument, second part, is that even if it was error, it was invited error and not prejudicial. In large part, because there is nothing about the shell patterns, ejected shell casings, that undermines, challenges, or changes the undisputed evidence that this defendant shot an unarmed man 11 or 12 times, and mostly in the back or sides. If you read the transcript of the charge conference, you will see that Judge Fox, the able trial judge, gave the self-defense instruction out of an abundance of caution. You will also see, if you read, and I would urge the court to read the state's closing argument, that the shell casings were not the linchpin of this case. In some 46, 47 pages of the state's closing argument, there may be 2 pages talking about the shell casings. So let me move to the first argument first. The standard of review is abuse of discretion. I believe that McGrady says, and all the cases since, and pardon me, this is when my pandemic hairstyle, I'm guessing, the West. But the trial courts have discretion in determining how to address the 3 prongs of the 702A case test. They must have the same kind of latitude in deciding how to test an expert's reliability. This is out of McGrady, Head Note 14. It also says that the ruling will not be reversed on appeal absent a showing of abuse of discretion. May be reversed for abuse of discretion only when a showing that the ruling was manifestly unsupported by reason and could not have been the result of a reasoned decision. So I think the weight of the case law is that this is a abuse of discretion standard. Mr. Glass, at one point in the defendant's reply brief, and I'm looking at page 3, the defendant argues, and I'm quoting from page 3 of the reply brief, that Mr. Glass had no knowledge, skill, experience, training, or education in shell casing extraction tests. That's not borne out by the record. Mr. Glass says specifically, he was trained. This is page, transcript volume 6, page 763. I certainly have training in how firearms work and the cycle of fire and how they eject cartridges. He testified in response to a question from defense counsel that shell casings and the ejection of shell casings is something within the purview of what forensic firearms examiners do. Again, from page 3 of the reply brief, it is not just that he, Mr. Glass, had no certification in this matter, he had no training. Well, there is no training in pattern of shell casings ejection. The defendant writes, Mr. Glass was not familiar with any of the literature on the subject. The record shows that Mr. Glass was asked about one report. He was not asked about other literature. Surely if there was more literature than that one report, Mr. Glass could have been asked about it. Mr. Glass was not familiar with that one report, but that's not the same as not being familiar with any of the literature. Defendant writes on page 3 that Mr. Glass had no experience. That's not borne out by the record either. Mr. Glass had spent his professional adulthood around firearms as a West Point cadet in the United States Army and the National Guard, as a sheriff's deputy, and then as a certified forensic firearms examiner. I also would point out the authorities the state has provided in its memorandum of additional authority. State versus Morgan is not necessarily an expert be experienced with an identical subject matter. The defense arguments about sufficient similarity are really arguments about the 3-prong test. The cases he relies on do predate the rules of the codification of the rules, and the rules of evidence and the law of the rules of evidence have evolved over time, as law does. And McGrady substantially changed the landscape of what is admissible and how it is admitted or not. I also want to, moving slightly into the second part, Mr. Glass did not give any actual opinion about the ejection pattern. He acknowledged that it was not a recreation. He acknowledged that he was not trying to show this precise location of the defendant. It was more about the movement patterns. And Mr. Glass, let me back up. During the argument after the voir dire, defense counsel said, and this is transcript volume 6, page 760. I suppose, Your Honor, if the state wishes to simply put him on the stand and say, you ran a test, yes, and you held the gun in these positions, and this is the way the shell's kicked, then I could cross-examine. And there's no opinion, there's no anything given, and I probably would not have as much of a problem with that. And that is, in fact, precisely how Mr. Glass testified. He got on the stand, he said he fired the weapon, or the weapon was fired by a fellow officer at different angles, and they measured the direction and the distance that the shell casings went out. That's what he testified to. That's what defense counsel said. I probably would not have as much of a problem with that. So there was no objection during Mr. Glass's testimony about any of that. There was only objection at 2 points. Once, when in front of the jury. There was an objection when Mr. Glass was asked how many times a semi-automatic handgun could be fired in a second, and he said 5 times. There was an objection to that. The defense counsel then relied on that statement, that opinion, in his closing argument. The second objection is when the state proffered Mr. Glass's written report and proffered it and asked it to be published and distributed to the jury. There was an objection at that point. There was no objection to any of the testimony itself. And the theory was that if a gun is being shot parallel to the ground, it's at a target that is likely farther away. And if it is shot at angles down, then that's where the ejection pattern goes differently. It goes to the front. Several members of the jury had said that they had never touched a weapon and had no firearms experience. This is why the state sought to introduce this, so that these members of the jury who had no firearms experience would know a little bit of something about whether shells go out to the front or back and when they do. It's not really so much about the pattern of the shell casings, but how they get ejected and where they go. The defendant's 2 cases that he primarily relies on are Faust, which I think is from the 1960s, in which a sheriff was found not to have the experience or training to qualify as an expert as to the specific gun at issue in that case. That's not the case here. And Jones, which is the more recent case, I believe, from 1975. And that case actually supports the state's argument. One of the holdings is that precise reproduction of the circumstances is not required to admit evidence of an experiment. And also the language about all of the points that the defendant is now raising and arguing go more to weight than to admissibility. Moving to the second part of the argument on prejudice. Again, the undisputed evidence shows that the defendant shot an unarmed man 11 or 12 times, most of them in the side and back. The state's case was that this was first-degree murder. The transcript and the record is rich with detail about the neighborhood disputes. I think if you read it, you will see that the victim and his family were the unpopular people with the rest of the neighborhood. And the state's theory of the case was that the defendant was goading the victim and that this dispute had been going on for a long, long time, and that the defendant was arguably goading the victim and picking on him. There is evidence that the victim was not a popular person and that he did a lot of things to make a lot of people angry. The state says that you don't get the death penalty for that. You certainly don't get it at the hands of the neighbor. At one point, the assistant district attorney says that the defendant brought a gun to what might have been at most a fist fight. There was no evidence. There was no evidence of any prior physical altercations between the victim and Mr. Turner. A lot of arguments, a lot of taunting, a lot of unpleasant stuff, but no physical altercations. The state's case, and again, this is what the court will see if you read the prosecutor's closing arguments. The state's case was more about the credibility of the defendant and that his story about this encounter, the prosecutor says dead men tell no tales. And the defendant was able to say, because he was the only living witness to the actual shooting, it was only his version that was in front of the jury. And the state pointed out that there were a whole host of inconsistencies between the defendant's call to the 911 operator, the defendant's station house interview with the police, and his testimony at trial. There were things, the defendant's story simply kept evolving. And the state's argument was that it was incredible that the changing story undercut the reliability of the entire thing. In particular, one is in pretrial statements, the defendant said he took a pistol to protect himself against Mr. Parker. There was no mention of the dog and putting the dog out of its misery. But at the trial, the defendant is suddenly an animal lover and wants to put the dog out of its misery. At the trial, the defendant says for the first time that Parker said he'd like to kill me like he killed the dog. There's no mention of that in any of the pretrial statements. Pre-trial, the defendant said he had the gun tucked in his waistband in his back, and he pulled it out and shot Mr. Parker. At the trial, he said, I had the gun in my hand the whole time, and Parker must have been crazy because he kept charging me while I had the gun in my hand, and he knew I had the gun. At trial, the defendant said he fell down as Parker advanced on him. Pre-trial, there was no mention of any falling down. So that's, in essence, is the state's case, Your Honors, that it was not an abuse of discretion, and that is the standard we're looking at. The trial court has great latitude in administering the three-pronged test of 702A. And Mr. Glass certainly had the training and experience to testify as to what he did. There was no objection during the main part of his testimony. The objection that was made about the number of times a semi-automatic handgun can be fired was relied on by the defendant in his closing argument. And the defense counsel specifically said, I have no problem if he takes the stand and says, this is the test he did. The gun was fired, and quote, this is the way the shells kicked. If that was error, it is invited error. And absent any questions, I'll rest on the brief.
Let me ask you one question. So as I understand your friend for the defendant's central argument is about the experiment, the reliability of the experiment itself. So you can imagine a situation where the question is, if you throw this paper airplane, how far, on a sunny day, calm skies will it go? And the test is conducted like in hurricane force winds. And in a situation like that, you could question where is that falling in, it's 702, is it A1, is it A2? You might question where exactly is it, but there's certainly some element of the test has to be similar enough to the actual setting that the data has some relevance when you apply it to whatever the methodology of the test of throwing the airplane. And as I understand your friend for the defendant, the argument is the conditions at the time were so chaotic that the controlled setting in which this experiment was conducted made it not reliable because it was not sufficiently similar to the actual circumstances that are at issue in the case. So what's your response to that argument?
Yes, I think the first part of it is I think it's under 702A3, applied the principles and methods reliably to the facts of the case. I would suggest that that's the specific part of this. And I would agree that if you throw a paper, if you're trying to test where an paper airplane goes on a sunny day with no wind, and the expert has done it in a hurricane, that won't work. And I think that is the gentleman's that says the question is whether something is too far wide of the mark. And at that point, it would be very wide of the mark. But I don't think that's the case here. That's a line drawing problem. I think that is relied under the case law and the precedent that kind of line is left to the trial court to administer the three prongs of the test and to determine at what point the expert's testimony is simply too far from the facts of the case. The fact in this case is that no one really knew the particulars of the encounter. The defendant admits that he shot the unarmed Mr. Parker multiple times. He had shifting explanations for why Mr. Parker was shot mostly in the back and side. He had changing stories over who was moving where and who was standing where. The state simply wanted to find out if a gun is fired at this angle, where do the shells go? And it's not really about the distance, it was more about the direction. And that would indicate whether people were moving and in what direction. And that is the essence of this. And I think there's substantial similarity, at least under the abuse of discretion standard, for that to be admitted in this case.
Thank you. Well, if there's nothing further, we'll hear from rebuttal from the appellant.
Thank you.
Thank you. It is true that to some degree, the particulars of the shooting that took place on the road were not precise, but there are many circumstances where the particulars were clear, and it was also clear that the experiment was different. The shell casings that were collected from the scene were made by 3 different manufacturers. The experiment used shell casings from one of them, not the other 2. The witness admitted that would affect how the shell casings were ejected. The testimony of the defendant was that he was backing up and eventually falling onto his back while the shooting was going on rapidly. The expert, the witness, testified you can fire 5 times in a second. There were 11 shots, it appears, from the injuries on the victim. So we're talking about 2 seconds. Grip. The other expert witness that did the matching of the bullets to the gun testified that some of them were fired with this limp grip. The expert, Mr. Glass, admitted that would affect how the casings are ejected. And in the experiment, there was no limp wrist. So there are substantial, numerous, time after time differences between the circumstances at the time of the shooting that caused the victim's death and the experiment. Now, whether you put it under the Rule 702, I don't think you can say that Rule 702 simply took an eraser and erased the law about what it takes to make testimony about an experiment admissible. Let me give you an example. Some of the cases, and they're mentioned in Jones, have to do with trying to replicate the circumstances under which a witness claimed to be able to see the event or identify the defendant. If the lighting is different, if the distance is different, if the other circumstances are different, case after case says that those are substantial differences. You can't offer that kind of testimony. And we're not talking about testimony from an expert. We're talking about testimony from a layman. This really isn't an expert issue. It's the question of whether the results of the experiment are admissible because they would help the jury understand the circumstances of the crime, or whether those circumstances are so different that they're likely to mislead the jury. In this case, They were different, they were likely to mislead, and they were used by the prosecutor. Now, in the prosecutor's closing argument, we've got 11 shots in 2.5 seconds, say. When that is explained to the jury to take apart this testimony, it becomes a 10 or 15-minute event with a pause between each shot. That was the argument. It's not convincing, but it was the argument. That doesn't mean that the evidence is so overwhelming that the defendant's testimony would be automatically disbelieved by the jury. Causing the jury to disbelieve the defendant, the state deliberately offered an experiment, saying we're replicate the circumstances of the crime. Well, if you're not replicating the circumstances, it's a waste of time at best and misleading at worst. And then in closing argument, use that experiment and the results of the pattern that came from that experiment to support the argument that the defendant was advancing, not retreating. It's that simple. The new rules of evidence after Grady don't change the basic question. And the basic question is, when you're this far afield from the circumstances at the time of the crime, that kind of evidence is simply not admissible because it has a tendency to mislead the jury. It has no probative value other than to mislead the jury. Unless there's any more questions, I will wind it up. I thank the court very much.
All right, thank you, counsel. Mr. Clerk of Court, we'll adjourn.
This session of the North Carolina Court of Appeals is now adjourned.
All right, thank you all. You're free to sign off now. And we appreciate your willingness to handle this oral argument.